Please help me to welcome our last but not the least speaker. Everybody's waiting for YB Barugan. Give him a big round of applause again.
Thank you, Charlie, for that simple introduction. Besides being probably the only man that will never grow old, by virtue of my name, I'm a man also wearing a lot of hats. But today, I assure you, I'm only wearing my legal hat, okay? Now, what I'm going to do in about 30-45 minutes is this. I want to explain and share with you basically the facts and the submission that we had submitted at the Federal Court in Masanda, so that you all know what came before the court. What were the issues that we submitted in the Federal Court? And then you will understand basically what's the debate all about. Because I read in the papers, I read in the WhatsApp, so many kinds of argument. Yeah? Let's just go to the issues itself, Masanda. Now my good friend, Doctor, was speaking on from a perspective of a scholar. Yeah? But today I'm sharing with you the perspective of a lawyer. Okay? Now, simple facts of this case is this. Plaintiff Masanda claimed 5,000 plus hectares of land called NCR land. Out of this 5,600, 2,802 hectares cleared and cultivated land, and this is the one that the government recognizes as the NCR. But balance of 2,712, they said that's primary forest hectares. The primary forest that is not NCR. Okay. Now, what happened is we won in the High Court all the 5,000 hectares. So we won in the High Court. The single judge ruled that both Temuda and the Pamakaian Manoan Perkara areas are NCR on the strength of Nornyawai. Okay. On the strength of Nornyawai that was approved by Medili Saleh case in a federal court case. I'll get to that later. Okay. Now that's the facts of this case. Now of course the government appealed from that High Court judgment. So they went to the Court of Appeal, and Court of Appeal agreed with us. They threw out the appeal. Okay. Then they went to the federal court. Now a lot of you may be asking, why did we allow this to come to this level of the federal court? Why did we allow all this to be decided by the federal court? And some of us say, oh, they are West Malaysian, macam-macam kan? But this is the process of law. It starts with the High Court. It starts with the dispute between the natives and the government that issues out provincial leases to a company, okay, that encroaches onto native custom land of the people. When there's a dispute like this, the only place for you to bring in your issues would be the court. And that's why we have a court system in Malaysia, starting from lower court. Of course, there's just constitutional court. Then you have the High Court. Then you have the Court of Appeal. Then you have the federal court. And that's why we ended at the federal court. Now, when you end up at federal court, it's not that as simple as an appeal. You must put before the federal court some legal question of laws. It's no more talking about the facts of the case unless necessary. Now we have to put a legal question of law before the federal court for the federal court to decide, and that is what we call the lead stage. Okay, if you fail the lead stage, you will be heard as an appeal in federal court. Now, what were the questions put before the federal court? These were the questions. Okay, whether the pre-existence of rights under native laws and custom which the common law respect include rights to land in the virgin pine forest which natives like the respondents, that the Toruma Sanda people, or their ancestors to our Iban Pares had not felled nor cultivated, but were forests which they reserved for food and forest produce. 2. Whether the High Court and the Court of Appeal are entitled to uphold a claim for native custom rights to land in Sarawak based on a native custom, namely pemakai menua and or Pulau Galau, where 1. There is no proof that such custom was practiced among the native communities, particularly among the Ibans, for the creation of rights to land prior to arrival of the first Raja in 1841. 2. Such custom has never reflected or recognized as having been practiced by the native communities in relation to the creation of the rights to land in any of the orders made and legislation passed by or during the Brook era or by the legislature of Sarawak, and such custom was never part of or recognized in the Tusun Tunggu and the Adat Iban 1993, which declared, pursuant to native custom laws ordinance, the customary laws of the Iban community in Sarawak. And the third question, whether the Court of Appeal's decision in Superintendent of Land Survey, that is not our case, that the rights of the native is confined to the area where they settle and not where they forage for food, is a correct statement of the law relating to the extent and nature of the rights to land claimed under the native rights in Sarawak. 3 general question can be unified in this question, which I put in Sweden. Now, my submission is given to the organizing committee. They will text or email to you guys, okay? It's all in there, and there are 2 folders. One is the submission, the second folder are the 2, in fact, inside the 3 very, very important case laws, which I'll refer as we go along. Now, the 3 questions can be united in this. Whether the concept of menua or menua and pulau or otherwise also referred to as Pulau Galau are pre-existing native custom rights or law over land, practiced before the coming of the Rajas and eventually recognized by the codified custom of the Ibans and the Tusun Tunggu and Adat Iban 1993, which basically are uncleared jungle or virgin forest as opposed to cleared certain areas called Tembudak where the Ibans forage for food. Now, although we are talking about the Ibans, but the facts of this case originated from the Ibans community, it is applicable to all the natives in Sarawak. That includes the Malays, the Kedayan, the Mirik people. Okay? Now, what does it involve? It involves the virgin forest, uncleared area, hunting grounds, fishing grounds, where we forage for food. Okay? Because the government so far only recognizes the Muda, fair area, okay, settled area, farm area, secondary forest. That is the only, that's the argument, it is sufficient. The only way the Dayaks or the native of Sarawak can create rights over land. Why? Okay. All this argument it boils down to interpretation of the law. Now, notwithstanding what Professor was talking about, where I'm getting us to the law. This is the land code. Okay, yes, it is passed by during the colonial time or the British time, but somehow inside there, we as lawyers have to search for this argument. Okay. Now, Section 2 of the present land code define native customary land in 3 definitions. The first one, land in which native customary rights, whether communal or otherwise, have lawfully been created. Very important, huh? The first thing you must remember, communal or otherwise, lawfully be created prior to the first day of January 1958 and still subsist as such. This definition is the crux of the matter. Okay? This is the argument where we debate in court, we submit in court based on this. And based on this argument, we won't know now. I'll get to that later. Now, the definition of the second and third is irrelevant for now. Okay? Now, the argument that we have here is very important. So when we talk about simply, we're talking about communal means pemakaian benua, pulau-pulau areas, the territorial domain, as well. Somebody mentioned that. Because we use this term, we imported, we accepted and submitted this phrase or phrases from other jurisdictions, from Canada, from USA, from South Africa, from New Zealand, from Australia, already imported into Malaysia, yeah? In one case called Adong case, before Nyonya Mai. So all this concept had been adopted into our courts and agreed to, okay, this territorial domain and forest reserve. Now, when you talk about communal, it cannot be Temuda, correct? Because Temuda is individual, whereas communal must be a rights over the land belonging to the community. And this is where I believe that the concept that they have is wrong. So the government's argument is that, okay, the only known method in creating rights over land is Temuda. They said you failed it, and then they got a lot of statement. Now we say no. This is the one that covers pemakaian benua, lawfully created prior to first January and still services as such. That's why you hear about the cut-off date. This is where it starts. Okay. So the government says, okay, we accept, recognize your Temuda only if you can prove that it was created before 1st 1958. After 1958, you must get a permit under Section 10. That's why this definition just now comes in. Sorry. This definition comes in already. Okay. You see, it says land from time to time comprises interior area land upon which stated consumer rights have been lawfully created pursuant to a permit under Section 10. So after 1958, you want to create batu bang, you must get permit from the survey. Okay, that's where the date here is important. Okay. Now, our argument is this. So what is lawfully created? Lawfully created. Then you must go to the definition of law. Where can you get interpretation? There is interpretation in the federal court, federal constitution. There is also interpretation definition in the interpretation ordinance or interpretation act. In this case, we go to the federal constitution, the supreme law of the land. Under Article 160 Clause 2, it defines law as this includes written law, common law, insofar as it is in operation the federation of any part thereof, any custom or usage having the force of law in the federation or any part thereof. Very important definition of law. So lawfully created means this. Common law. Common law are not written law, no? But this is very important for us. Custom or usage having the force of law. Now what is custom and usage having the force of law? Now all those are in our submission, yeah? If you have the copy, go through that, the detail is there. But I'm just trying to summarize it. Our submission is this, okay? Having the force of law means that custom, and I think in the dissenting judge, the dissenting judge correctly pointed out. In fact, her judgment incorporated all our submission. It's almost like cut and paste, okay? So the dissenting judge agreed with all our submission. Now, for a custom and usage to have the force of law, you don't need it to be codified. Okay? We have authorities on that. It means that custom is in existence. 3 requirements needed. 1, that custom is certain. 2, that custom is reasonable. Like now, head hunting is not reasonable, kan? That was a custom in the past. So it's not reasonable. But if it's reasonable, second. And third, it is still in practice today. 3 requirements. Then that custom becomes a force of law in accordance with this definition. And in fact, we submitted in one case, in Negeri Sembilan, Anyam case. It's all inside the submission. The word and the phrase is exactly this. What is meant by having the force of law? Custom having the force of law. And the time the British judge made a decision, it means the adat perpate in Negeri Sembilan. It means the adat itself, which was not codified at all. Okay? So that's our argument before the court. And that argument was accepted in Nyonya Wai, confirmed in Medley case, which means the argument of the government is the opposite. Now, why is that they are saying that that is wrong argument? Because they are, sorry, I didn't put down on the transparency. They are arguing like this. And this is the same argument that was raised in Nyonya Wai. Okay? In fact, this debate is not the first time being argued. It's the government is saying that Nyonya Wai was not being finalized at the federal court. That's a lie. Okay? Now I'm reading now the Nyonya Wai at High Court level. Okay? And I want you to listen very carefully because that argument is the same argument. And in fact, this is what Yan Chin says. But it was argued that absence of any reference to or mention of the terms pulau or pemakaman in the Dusun Tugu meant that such custom was not native customary law, since they do not come within the definition of customary law of the Land Classification Amendment Ordinance 1954, which state, now this is the argument, because customary law, according to Land Amendment Ordinance 1954, defines, I quote, a custom or body of customs to which the law of the colony gives effect, unquote. The following sentence of Richard, page 9, was referred to as supporting that view. As was pointed out by Moni as Crown Counsel and Heckling, the law does not in fact give effect to any custom whatsoever except the codified law of the delicts. Now that's the argument of Joseph Fung. Okay? Just because of this definition. And how did Judge Yan Chin address this? Then he went on. The matters of the Muda Pulau and Pemakaian Benua were already recognized by their being mentioned in the various orders and references which I have earlier referred to, and therefore the law of colony has indirectly given effect to them. I think John was referring to the tribe law and all those, okay? That's what he's referring, because if you read the judgment, all those he mentioned already. Because Yan Chin, when before Brooke came in, and he traced all the land orders, okay, and decreased until 1958. And this is what his conclusion. Then he says this. I have earlier referred to, and therefore the law of colony has indirectly given effect to them. Native customary law, before its codification, was not in any legal written form, but a matter of proof. Native customary law existed and operated side by side with the orders and other legislation of the Rajas until they were abolished by the Raja. See Professor Douglas Sanders in Galdes Adong Kuau Mabo Supra. Now that's his comment, okay? Therefore, even assuming that those rights of the Muda, Pulau and Pemakaian Benua were not expressly mentioned by any written law, it does not mean that they could not exist as native customary law. They exist, and in this regard, I have already adverted to the evidence and found them to exist until abolished by orders or other legislation, for which also I have concluded that they had not abolished those native rights, which are also equated as native customary laws. Now that's part of his mention in the judgment, and then he also addressed that earlier on, and he said this. The same argument when he addressed the lawyer for the company. Then he said this. The explanation therefore, the Raja recognized the customary law and that it has the meaning I have earlier mentioned. If necessary, another apt description of native customary right would be that used to describe native title in Mambo number 2, which is that, quote, it has its origin in and is given, it's contained by the traditional laws acknowledged by and the traditional custom observed by the indigenous inhabitants of territory. It is therefore not dependent. It is therefore not dependent for its existence on any legislation, executive, or judicial declaration. He got that from the Whigs people, the High Court decision in Australia against Queensland. This is the highest court in Australia. I was federal court, but this is High Court. Though they can be extinguished by those acts. Therefore, I am unable to agree with Ms. Cow that native customary rights owe their existence in statutes. They exist long before any legislation. And the legislation is only relevant to determine how much of those native customary rights had been extinguished. Decision of Bian in Non-Dawai High Court. Okay? Now, what happened to... and as I said, this was argued within Non-Dawai, no? And re-argued in Kurmasanda. You see? Because they keep on appealing, they kalah. And I tell you here, more than 10 cases we won at the High Court and the Court of Appeal, okay, based on the authority of Non-Dawai and Merilisana. Okay? And it's really settled. Now what happened to Non-Dawai? Okay, we won at the High Court, then they appealed to the Court of Appeal. At the Court of Appeal, the Court of Appeal had 3 judges. We lost on the finding of facts. Meaning to say, they said, look, you call it pulau, but there's no evidence to say it's pulau. That's what the judges says. But we want to affirm. I don't want to refer to the authorities here, but it takes time, okay? Let us, the 3 of them, the 3 judges says, we wish to affirm the other aspect of the judgment of the High Court. And that is, they said, they list up A, B, C, D, E, you know. You know what they said? All the custom, aspect of the custom, of pemakai menua, pulau galau, tembawai, extra, are the correct position of the law in pertaining to custom. Court of Appeal. So we lost on the fact of finding of fact. Then they added in there. They said, look, this case cannot be as a precedent to say that pemakai menua, pulau galau cannot be recognized. But another case may come with good evidence, the court can declare that rights is valid. So we were surprised that they didn't appeal in Non-Dawai, no. Why? Because then we found out Medeli case came back after Non-Dawai. Medeli is a Malay case from Miri. His argument was that he also got NCR over his piece of land. So what happened was the government took and acquired the land for a building of school and some public purposes. Then he challenged the extinguishment of his right. And he said that I had been living on that. My father was born there in 1922, you know, and therefore I have NCR rights. A Malay, okay? The same argument applies. Then he lost in the High Court. Why? Because Jesifung argued your NCR was extinguished automatically because in 1921 there was an order by the state government to give that whole area to Shell, perhaps, okay, for the exploration of petroleum. Now, because of that, you lose your right. So he lost that in the High Court, but he appealed to the Court of Appeal, Medellin. So by the time he came to the Court of Appeal, Nor Anak Dawai came out in the High Court already. So he used Nor Dawai punya decision. You see, this is what called stay decisis in a court of law. You can refer to authorities. For our case in Malaysia, we can refer to authorities in the Commonwealth countries. They are what we call persuasive. They may not be binding, but apparently our court has adopted all these authorities. The Caldas case from Canada, Mabo case from Australia, yeah, Amiju case. All these are adopted and followed, you know. Now, Medellin came to the Court of Appeal, he won. Okay? And the judges said, look, that order does not automatically extinguish this right. For it to be extinguished, it must be properly done. Second, he must be compensated under the land court, under Article 13 of the Federal Constitution. So he won. Now, what happened in the case after court appeal? The government appealed to the federal court. Now, as I've said earlier on, if you go to the level of federal court, the issue now is a question of law. You must put before the federal court some question of law that has, one, it was never decided before, the issue. Two, it has public interest impact. So of course, when Madili came to federal court, leave was granted because they said this is the first time the issue of pemakai menua is to be debated. Now let me read to you the question before the federal court in Madili Saleh case, yeah? So that you know that actually this is already settled in Madili case. Okay? Now, there are 6 questions put before the court. Only 2 questions were relevant in Madili case. And this is the question. These are the questions. First, whether the rights of natives to occupy untitled land in accordance with customary laws could have subsisted or would have been lost or extinguished in the area reserved for the operation of Sarawak Oil Fields Limited pursuant to Order Number 29, 1921 made by the Raja. And the 5th question relevant to our debate, whether, okay, having regard to the provision of Section 3, 1 and 6 of the Civil Law Act 1956 and the relevant federal, state and customary laws in Malaysia and particularly in Sarawak, which regulate the creation, exercise, loss, abandonment and extinguishment of native rights over land, the Court of Appeal in this instant case, and indeed in the courts in Malaysia generally, could they rely on 1. Adong Kuau case against Kerajaan Negeri Johor 1997, 2. Nor Anak Nyawai against Benua Plantation 2001, which were decisions based upon 2 very important cases. The Australian case of Mabo No. 2, which is an authority for the proposition that the common law of Australia recognizes a form of native titles, and 2, the Canadian case of Calder against the British of Columbia, which held that common law categorically recognized native rights of the land. Very, very specific. The question before the court was whether Adong Kuau and Nor Nyawai were correctly decided. What was the answer of the federal court? Now, let me tell you this. We submitted this before the federal court in Kuala Lumpur, okay? We submitted this. What was the conclusion? Now, the conclusion of the federal court, of course, the same thing, argument, the Sifung argument is the same thing. They court on the enforced law, custom have no force of law in Sarawak. Same argument. And he quoted also the Land Classification Amendment 1954. Okay? The same argument reached the federal court in the case. Finally, the federal court decided in many cases. As for the 5th question, our answer is that we wholly agree with the view expressed in Adong bin Kuau and Nor Anak Nyawai, that the common law respect the pre-existence of rights under native laws or custom. Simple question. What was Nor Nyawai case about? Tell me. About what? The question of whether pemakai menua or Pulau Galau create rights. Correct? No other issue, but it's nothing to do with Temuda. And that's where the judgment of the majority in Puerto Masanda, if you read the judgment, I put it on Facebook, yeah? You can access to it. And they're saying, they're trying to say that Madili case has nothing to do with pemakai menua and Pulau Galau. It's only pertaining to Temuda. The continuous occupation of rights over land relates to Temuda. What's a nonsense, you know? Second, you know what they said? Because they agreed to, of course, to the AG punya, just so you know, AG now. They agreed to justice for submission to say that Because pemakai benua and Pulau Galau were not codified. It was not in the Dusun Tugu. It was not the Adat Iban. Therefore, it cannot have rights. It cannot create rights. It's not the force of law. Full stop. Yet, in the judgment, if you read, the judgment of the majority, you know what they did? They agreed to all these cases, you know. Starting from Caldas, Canada, Mampo, they went all the way to Amicu, Delmago. They went to Adong Kuau, they went to Saruntasi, they went to Nonyawa, they went to Medellin. And I tell you, all these decisions and authorities, they have one common principle, legal principle. That is what I write just down. Nonyawa, he says that custom and adat of the indigenous people worldwide, not only in Sarawak, you know, they're using all the authorities worldwide, does not depend on statutes. Understand?
Yes.
It does not depend on statute. Meaning to say, it can exist on its own. Even if it is not put into a codified law, even if it is not put in a statute, okay, it still can exist on its own. It has the force of law. And yet, in Peru Masanda, the conclusion of the majority judgment was that, oh, it was not codified, contradicting to their own affirmation of the other authorities. Now, that is in a nutshell, okay? In fact, I have done all this law. Now, what we have done, in fact, in our submission, just to brief you, because the question then put before us was this: question of whether the pemakai benua concept actually existed even before Raja came to Sarawak. So what happened was they're trying to put the burden on us to make it so difficult for us to prove that this custom actually existed even before Raja came to Sarawak. But we went into history. I went to research. We, of course, on our case, only we dealt with that. So we have all those articles. So what we did was this. We started before the book. So the first part of my submission, okay, we went into history. So we started, okay, before that, in this case of Peru Masanda, the government, in fact, eventually, they said, they considered, you know, that this custom exists. So anyway, before I knew, in fact, they already considered. It existed even before Raja came to Sarawak. And they also admitted that it is still in existence today. But they said it has no force of law because it was not codified. Understand? So what we did in the submission, we went beyond main submission, we went into history, we quote Frederick Porter in 1967, okay, talk about pemakai benua, and then went on to Robert Maxwell Pringle, also writing in the 1960s, okay, then he talks about all this definition, no problem with that. And then we went on to Richard, Agent Richard, Dayak Adat Law. He wrote something about the Dayak Adat Law. In fact, there is some mention of that in the Dusun Tugu. And we pointed it out, okay? Eddie Ward wrote about the Adat in the Krian area, Waigali area, also mentioned about all this. Then we went on to Richard's report, okay? This is very important because this report was filed by Richard, Agent Richard, upon mandate given by the state government in 1961 already. Now, if you read his report, all this concept were recorded. What was system of reference? This was system of reference. Find out past practice and custom relating to land in Sarawak. And about 2, 3, research into history and custom. And when he did that, he came up with a report, and all the reports talk about this. I just got a few lah. What is pulau? He may define it. What's manua and pemakai manua? All those references we put there. And in fact, this is the preamble to the, now, the next one. Okay, Agent Richard. Then the next document that we relied on is this. We call this the Secret Circular number 12, 1939. earlier than the Agent Richard document as well, in fact. So what did this thing record? Look at this preamble. The landholders recognize native custom rights to land, but give little guidance on the subject. The law of custom Indio is wrapped up with that of inheritance, and neither has yet been adequately codified. It is the aim of the government to record and protect these customary rights. Okay? Then, if you get into this circle, it's very long, and then you realize, in fact, many of this paragraph talks about communal territorial rights. Rights over watershed, right over hunting grounds, you know, over rivers. These are virgin forests, they are foraging areas of the natives. All mentioned here, you know. Okay? So then, of course, there's a history lah. Then we came to the modern authors, include our dear professors now, okay? They have written all this. Okay, they have written, these are people like, we got Professor Dimba, we got the late Tan Sri Datuk Bersinombat, and we got Rami Bulan, Suhakam report, Jalamu, and of course Nicholas Bawin came in as a witness in the case. What are we trying to do? We're trying to tell the court, look, the same concept is understood by even our modern Dayak authors and people. It never loses its understanding. So in terms of definition, okay, in terms of definition, all very clear in this, okay? Very, very clear in our submission. Okay, so after that all the rest are quotation by all this one. Then eventually the second part of our submission basically is this. Oh, sorry. Let me mention about BC Jigut. BC Jigut case went up to the federal court. It is pertaining to the sales of Tamuda. You cannot sell NCR land, Tamuda land. But then now you know that you can because they amended the law. Okay? Now, even in that case, although it was pertaining to Tamuda, Richard Melanjun, the Chief Judge of Sabah Sarawak, very cleverly, in fact, I think he tried to re-emphasize that Nur Nyawai was correctly decided. Pemakai Menua Pulau Galau were already decided by Nur Nyawai. In fact, I quoted a few of his part of the judgment in BC Jigut. And this one is federal court, you know. Affirming Nur Nyawai. Okay. So the second part of our submission basically is this. Is the Pemakai Menua Pulau Galau a custom or usage having the force of law within Article 160 of the Constitution? And two, does the Iban custom of Pemakai Menua and Pulau Galau give rise to enforceable native custom rights at common law? We submitted, if you look at our detailed submission, we said yes. Two prompt submission. One, we say that it's having the force of law. Authorities we put in, including Anyam. Thirdly, okay, or secondly, authority says, if it is a common law practice, what you need to do is just to prove that that practice exists. Prove that practice exists, that custom exists. And once you have proven that, it has the force of law. Understand? So it doesn't need to be codified. As long as the custom is practiced, it has the force of law. So that's the second, the last portion of the submission. So unfortunately, of course, 3 judges went against us in the Rumah Sanda, and then one only dissenting, who agreed to us totally lah. Okay. I went further, but let me just conclude. Before this, there was visiting. Sorry. Okay, I can't find the place. There was a visiting professor from Australia that he commented on all this stuff. And then what he said is this: that decision that you try to cut off the natives from the rights in the foraging area or in the hunting grounds area is very unfortunate. Because when you do that, he says that they cannot survive. because they depend on the foraging area, pemakaman area, to sustain the livelihood. If you don't allow them to have rights over there, only untuk muda, they're finished. Okay. So what's the way forward? I agree with Professor Chu and a few of those who I said earlier. The way forward is no two ways about it. No ways about it. Now the only thing when I thought about this, I was only thinking of this last minute, moderator. The only way actually, if they want to control, if the government want to say, okay, we are men. There's no two ways about it. It satisfies everybody, left and right, up and down. No such thing, you know. Either you recognize pemakaman Pulau in the land code by amending it, or you don't. When you amend the law, the only thing that you're concerned of is this, whether it has a retrospective effect. Understand? Like this is a good case. We lost all the way to federal court. So what we did? Yeah, amend the land code. When we amended the land code, then they said, okay, you can now sell, native can sell NCR land to any natives now, cross community only. But they said it has no retrospective effect. What does it mean? It means that whatever transaction happened before the amendment is still not valid. Okay? Only after the amendment, then you can sell. Now, pemakaman cannot be done like that one, no. No retrospective issue. It's either you recognize it or you don't. Don't tell me the pemakaman before this amendment you cannot recognize. Only now you recognize. Cannot. Cannot can, because this is a creation by virtue of custom. Thank you very much.
Thank you very much, Yang Berhormat Baru Bian. Let us give him thunderous applause, please. I think he has answered all those that we are wanted. But please stay on until the end of the session because we have very more interesting things to come. This is my assurance to all of you. Things will change. Remember, a leader will not only watch things happen, but he makes things happen. And we want by this evening, it will make it happen to support our lawmakers. Yeah, so these are the things as well. I said, sorry, I'm not a lawyer, but anyway, I'm premature to mention that we are part of the team. I'm not a lawyer, but I'm happy that I want to see with my own naked eyes one day that our native court is at par with Sharia court and civil court. This is what we want. And we want in the future that whatever related to native case to be handled by the native. Whatever cases in Sarawak to be handled at the state level, no more at the federal level. This is what we want. Who made this happen is all of us here. Yeah, these are the things. Sorry, I talk so much this to uplift the spirit of you because all of you already feel very sleepy. I hand over to you, MC.
Thank you very much, Dr. Charlie. Next.
Hello. Sorry. One last.